Welcome to Mr. Criminology, where we share for you to learn and succeed. In this video, we will be discussing quasi-recidivism under Article 160 of the Revised Penal Code. Ano nga ba ang quasi-recidivism? Quasi-recidivism happens when a person commits a felony after having been convicted by final judgment for another crime before beginning the service of such sentence or while serving the same. Habang nasa kulungan ka or after makonvict ng isang felony, gumawa ka ulit ng krimen. Sa nabanggit po, may dalawang elements ang quasi-recidivism. First element, the offender was already convicted by final judgment and sentenced for one crime. Article 160 is silent whether the first crime is a violation of the Revised Penal Code or a special law. However, the Supreme Court said na regardless po kung violation siya ng Revised Penal Code natin or Special Penal Law. Second element, that he committed a new felony before beginning to serve such sentence or while serving the same. The second offense should be a felony or the second crime committed must be a violation of the Revised Penal Code. So, kailan naman nagawa yung second crime? Sabi sa batas, before beginning to serve such sentence or while serving the same. For example, when the second crime is committed habang binabiyahe ka papuntang kulungan, habang nasa kulungan ka, o habang nakatakas ka sa kulungan, tumakas ka tapos gumawa ka ng crime. Kindly remember the following. Quasi-recidivism is not a felony, but a special aggravating circumstance. So, what is the effect kung special aggravating circumstance ito? The effect is to impose the maximum period of the penalty applicable for the subsequent or second felony. Thus, it cannot be offset by ordinary mitigating circumstances. Kunyari, ang penalty is prison correctional minimum to prison correctional maximum. Ang ipapataw sa'yo, dahil quasi-recidivist ka, yung maximum. The first offense may be any crime, but the second must always be a felony. Now, let us discuss the second paragraph of Article 160, which is pardon. When a quasi-recidivist reaches the age of 70 and he has served out his original sentence, he may be pardoned. He may also be pardoned if he finishes serving the original sentence only after he reaches 70. Kailan naman hindi applicable itong rule na ito, or reason for not pardoning such a 70-year-old convict? First, he is a habitual criminal. Second, if his conduct or other circumstances shows he is not worthy of such clemency. For example, pasaway siya sa kulungan. Thank you for watching. If you like this video, don't forget to share it and to subscribe.